My presentation is about legal realism. Legal realism is a philosophy of law that opposes the idea that the law is just a set of logically created rules that are always followed logically and impartially by judges. Legal realists believe that judges follow the law, but also intertwine their decisions with their own personal beliefs and public and social interests when rendering their decisions. Some believe, for example, that judges come to a conclusion first and then use the law as a way to get to the decision they want to make. In the late 18th to early 19th century, legal realism was developed as a response to the classical theory of law. The classical theory, called legal formalism, believed the law to be a science where a question could be asked and answered with certainty using the knowledge of court decisions and legislation which generate law. Essentially, the outcome would always logically follow from a major premise established by a legal rule. In legal formalism, judges never even have the ability to use their own judgment or interpretation when deciding a case, because, in a legal formalist view, the rule of law is paramount and always followed, preventing any and all bias within a courtroom. Legal realism started as a challenge to this idea. Psychology was developing as a brand new field of science around the same time that legal realism was being debated. Legal realists were interested in the idea that humans were products of their environment and the idea of a subconscious mind that influenced our decisions. Legal realists began to research the law and discovered it to be a much more broad subject than initially believed. The law is flexible, with terms having multiple or open ended meanings that are open to interpretation. There were many philosophers who focused on legal realism, and one of the first was a man named Oliver Wendell Holmes Jr. He was an American jurist who served as an Associate Justice of the U.S. Supreme Court from 1902 to 1932. Holmes was one of the first critics of legal formalism and paved the way for legal realists with his book, The Common Law. Holmes's central belief was that the law was not a system of pure logic or belief, but an institution based on human logic, history, experience, and social class. This was described in Holmes's famous quote, "The life of the law has not been logic. It has been experience. The felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have had a good deal more to do than the syllogism in determining the rules by which men should be governed. The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if only contained through the axioms and corollaries of a book of mathematics. In order to know what it is, we must know what it has been and what it tends to become." This quote by Holmes showcases how he views the origins and nature of common law. Common law comes from personal and lived experience as well as current political and economic trends. The law takes into account the past and develops over time, changing into something that fits the current needs of society. Judges may interpret an ambiguous law in a way that they believe advances society, or in a way that they believe to be immoral, even if they're not required to. A judge's conscious or unconscious biases may also play a role in determining the outcome of a case in Holmes's mind. Holmes makes sure to differentiate the law from objectivity from something like math, which is routinely promoted as rigid and objective. The law is not something that exists purely in statutory form or through case law. It must be studied as if it is a living thing that changes over time. This is what will become to be known as Holmes's prediction theory of law. Carl Llewellyn was also one of the first philosophers to tackle the idea of legal realism. Llewellyn was inspired by the German free law movement, which disagreed with the legal positivist way of thinking that was in the legal system in Germany at the time. Legal positivism is the idea that the law is correct because it comes from a position of authority, and that even if a law is unethical, it is still valid if it comes from a statutory authority. The German free law movement more closely believed in the theory of legal realism. Llewellyn believed that in most cases that reached the appeal level of review, the law was undefined. He believed that statutes and case law in these scenarios usually wasn't enough to justify rendering a unique decision. The unsettled nature of this case law was usually caused, in his mind, by the existence of multiple valid yet conflicting ways to interpret the law as it was written. As an example, Llewellyn cited the American courts advocating for two different yet conflicting positions on statutory law. That being, a statute cannot go beyond its text, and to affect its purpose, a statute may be implemented beyond its text. Because of these conflicting rules, a court could legitimately come to two different yet equally valid interpretations of law. Llewellyn believed that because of the conflicting nature of such laws, a judge was effectively unbound by precedent. They could interpret the law loosely and then broaden the case and only focus on the general principles found in the case, or they could view it strictly and focus only on the specific facts of the case. Llewellyn believed that the judge's decisions could be predicted, just not by looking at mere case law, which was the case for most legal realists. Legal realism is present in modern day legal thought and teaching as well. For example, a legitimate reason for a judge to distinguish a case is that social norms have changed from when that case was originally heard. When people are being taught law in school, they are also taught about the fact that the law is generally affected by the emotions of the judges in that particular case. An example is Crinson versus Toronto. Another point that shows legal realism in real life is sentencing considerations. If the law was static and you could input the facts and always receive the exact same sentence, then there would be no need for things such as the Gladue factors or considerations of a person's minority status in sentencing. These would be irrelevant in a legal formalist view, but are indeed necessary to explain differences in sentencing if the world was truly under a legal realist way of thinking.